Hi. All right, let's talk about the handout that we did not get to in class. Specifically, this handout, the one that says headings, topic sentences, and argumentative style. Okay, headings. Let's start with headings. Why do we have headings? Well, they serve a practical purpose. That is, if you, the reader, only wanted to read about, say, the Sixth Amendment arguments, you could use the headings to find where that is in the brief and then quickly go there. Otherwise, without headings, right, it would just be page after page of argument with no easy way for the reader to navigate between the arguments. Okay, but they also serve an argumentative purpose, right? The theory being, if I read only your headings, I would get a summary of the argument. So the summary of the argument is not just a what summary, that is what conclusion you want, right? What areas of the law are involved, but it's also a why, right? The why is the most important part in a brief, right? The why provides the reasoning for the court to want to do something. Now you get to the why primarily with facts, with fairness, and with public policy. So case law is instructive because it gives past courts reasoning, past courts whys as to those facts and that public policy, and you can make analogies with it. But the analogy is as to the why, not the what, right? We can distinguish cases with the what, that is specific facts, or with the why, that is logic. But really, what matters in the end of the day is the why. I have the hardest time getting students to just make logical arguments based on the fact and fairness. You seem to want to do mini brief, mini brief, mini brief, 3 sentences about your case, our case, and then a conclusion. That is the legal equivalent of when in 4th grade you would stand up and start a speech with, well, the Webster Dictionary says, right? We need to move along. We need to use the facts. We need to use public policy. At any rate, we need to get to the why. Headings can help us get to the why. Okay. So in my handout, I've written out 4 headings as if I'm writing the Roman numeral 2 for Real Party's Sixth Amendment issue. I could have picked any of you. I just happened to pick that one. The very first one reads, the SCA violates Real Party's Sixth Amendment rights. Okay, well, that is an accurate description of what the reader will find in Roman numeral 2 of a Real Party's briefs, correct? The problem is it doesn't say why, right? It doesn't say, there's no because thought. If you want to have a statement this short and cursory, I would ground it in lower court error. That is the traditional way to do a major heading, like a Roman numeral 1 or 2, is to ground it in a lower court's error. So you could say the court below erred because the SCA violates Real Party's Sixth Amendment rights, or something along the lines of that. But we need to juice up this first bare bones statement. Okay, I consider ones like the first, the SCA violates Real Party's Sixth Amendment rights, period, as being sort of almost like a place filler. Like, yes, you're telling me that this is going to be the Sixth Amendment argument, but as a reader, you give me nothing on which I can decide if I agree with you or not. Does that make sense? Okay, the second one. The second option, Real Party's rights are violated by the SCA as applied pursuant to the Sixth Amendment. Again, completely accurate statement. There's no real why here, so the why problem is the same, but there's an additional problem, and that's the passive voice, right? So essentially, the first 2 statements are saying the same thing. One is active voice and one is passive voice. So if you're going to be this bare bones, at least have the decency to use active voice. Okay, the third one. It should be the Sixth Amendment compels provider disclosure of social media content in this case because this evidence is crucial to defending against the state's charges and cannot be obtained by other means. Okay. Better than the first 2 because you get to the why, right? You know that the reader now knows they're about to hear a Sixth Amendment argument, and they have a couple reasons why, right? Because the evidence they want is crucial to the case, and they can't get it for another reason. You at least are like, oh, okay, I could see why that would be a problem, right? You've at least primed your reader for something beyond you're about to hear a Sixth Amendment argument. The downside to this one is it's a touch long. Sometimes that just is what it is. Writing cannot be either too long or too short. It can only accurately convey your thought or not, right? It can efficiently convey your thought or not. This sentence is long, but it's not horribly inefficient, but it is a style choice. You favor long headings or you don't. I personally would probably go with a heading like this, but I would also understand why someone would want to make it shorter and punchier. Okay. The fourth one, it is a constitutional violation to deny real parties, there should be a apostrophe there, access to subpoenaed social media posts. Okay, here's my problem with this one. It is a horribly weak phrase. It's a horribly, your main verb is. That is not an action verb as much as it's a being verb, right? It is, and bald pronouns like it when there's no noun to tie it to is just, it's just a placeholder, right? So I'm not a fan of the weak wording. I'm also not hugely a fan of calling it social media posts. Again, always be afraid of the older judges not understanding what social media is, content, evidence, things like that, documents. They're not really documents, data. Consider using that versus posts because it's not clear exactly what a post is. It might be completely clear to you, but it's not, never underestimate how non-tech savvy judges are. Okay, all right, and that is headings. So when you're crafting your headings, try to get to the why, keep an active verb, and direct statements, and do read all of your headings as just one bit, as one holistic piece, and see if you've accurately told the reader what your argument is and given a flavor of the why. Headings, that's what we're doing. Okay, topic sentences. Oh, topic sentences. Wouldn't it be amazing if you all used them? Okay, I give this lecture every year, so don't take it personally. Okay, some of you use them sometimes, but not other times. What is a topic sentence? Well, as I have written, a topic sentence is a sentence that expresses the main idea of the paragraph in which it occurs. It's usually the first sentence. It doesn't have to be the first sentence. I would love you to just have one. I think shoot for having it be your first sentence in legal writing because legal writing, argumentative style should be very direct. And very, you need to give your reader a lot of signposts. And when you have the topic sentence as your first sentence, the topic sentence serves as a signpost for what's happening in the remainder of the paragraph, and often remainder of several paragraphs. If you're about to say there are 3 points that, right, then I know I'm sort of expecting to see 3 paragraphs, and I now have a structure in my head for reading those 3 paragraphs. I have an organization and an expectation. Readers who read with expectation, provided expectation, read the content that they're given. Readers who have no signposts, don't have a context, they read for, they're reading for both. They're both reading for the merits and to understand what your organization is. You don't want the reader thinking about your organization because you want your reader thinking about the merits. Yes? Okay. All right. Topic sentence. So I have given, the top one is, the top example is from someone's brief. Okay, so this is a heading, a subheading 1. Real parties do not have access to the social media account records under this court's ruling in Hammond. Okay, so this is true. And then the very first sentence is, this court has also declined to extend a defendant's Sixth Amendment rights of confrontation and cross-examination to authorize pretrial disclosure of privileged information, and they cite to Hammond. Okay, the problem is, there's no, that's not a good topic sentence. That's in fact not a topic sentence, and it doesn't let the reader know what's about to come, right? Consider the example that I wrote. First of all, I have rewritten the heading, right? Hammond bars real parties' pretrial access to subpoenaed social media content. Much more direct, right? Much more matter of fact. That is pretty standard argumentative style for an appellate brief. And then I've given a topic sentence. Real parties put forth no tenable reason for this court to overrule Hammond. So now my reader knows we're going to be reading about Hammond, and I'm expecting an argument that explains why we shouldn't overrule it, right? A topic sentence has now given the reader a signpost of what's to come, versus just launching into a generic discussion of Hammond. Because when you launch into a generic mini brief, the reader is sitting without a topic sentence. The reader is wondering, well, where is this going? Because I'm seeing a mini brief, but I don't know why I would read this mini brief. So now I'm trying to figure out why I'm reading a mini brief, and I'm trying to digest the content of the mini brief. Okay, no, you don't want the reader to have to think that hard. You put in good thought, good organization, and let your reader just digest the merits. Yes? Topic sentences. Let's work on them. Goal. Think about it this way. If you just wrote down every topic sentence in order in your brief, I should have a summary of the argument. Yes? This is true. So think about it that way. Every paragraph, if you were only to select just the topic sentence from every paragraph, I should have a summary of the argument that should make quite a bit of sense. Okay. Alrighty. Argumentative style. All right. So there's predictive writing, right, which is like what you would do for a memo if you were at a firm and someone came and gave you the assignment and said, hey, we have a client that came in that wants to know if they were to do such and such, what might be their liability, what might be their exposure. And then you're giving a very hem and haw, right? Like, well, this court has said in this circumstance this, but we have slightly different facts here, and therefore it's reasonable to expect blah, right? It's a very hedgy type of language. Okay, that is not how you write argument. Things are so, right, with argument. It's very direct. One side has an opinion, you have your opinion, and the judges are going to decide, right? You go in with a point of view, unapologetically so. You're not a jerk about it, and we're not being derisive, and we're not trying to smear the other side or whatever, but it is very direct, and it's a very distinct point of view. In line, the style of argumentative writing is much more direct and to the point than you guys have been writing. You guys most of you are writing sentences when you're giving black letter law of, well, the Wardius court, da 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 da. Okay, if you're giving black letter law, say it, right? So look at my example. So consider the difference. Interpreting the due process clause, comma, the United States Supreme Court has held that there must exist a balance of forces available, the prosecution and the defense, see Wardius. Okay, versus mine. The due process clause requires a balance of forces between the prosecution and the accused, period. Very straightforward. Both sentences accurately give the black letter law. Mine is better argumentative style. Also, it's not a C cite. That's what Wardius says, right? A C cite is when you're making an analogy, right? A C cite is when a case it's either for dicta, right? Or it's for an analogy. And this is a holding of Wardius. So that's the difference. I hope that works for you. Please email me with any questions and think about your style, your topic sentences, and your headings. All right, thanks so much.